We'll start with Emel. Hi, Emel. So how do you see, or what are your thoughts about the global development of comprehensive data protection laws?
Thanks, Noor. So in terms of legislation, of course, we need to start with GDPR. The EU General Data Protection Regulation, known as GDPR, is the most comprehensive and demanding regulation about data privacy of all the times. And this is influencing all the regulations of other countries. I mean, in terms of local regulations, it is a huge inspiration. GDPR is not only regulating the data privacy, but it is also setting very material and clear safeguards, and also regulating the rights of the data subjects. So this is completely a mindset change in terms of how the world was managing data. And in terms of countries, for instance, as an example, Thailand, Brazil, Australia directly implemented the GDPR regulations nearly as is. And meanwhile, some other countries prefer to make some deviations as per their local specifics. But at the end, it would be fair to say that GDPR is setting the standards about data privacy all around the world. That said, well, to my view, data privacy is very well respected. I mean, at least if we look at the last decade. And if you look at the countries, for now, I think it is around 160 countries have their local data protection laws, which is a really good number. And I think previous year it was like 145. So the trend is increasing, really. And majority of the countries, majority of the companies understands the importance of data protection, and of course the benefits that it is coming together with. But also it is coming with a price. It is coming with a very good amount of time and effort and cost for all the companies and organizations. And here the landing point this brings us is the data strategy. So all these comprehensive data protection laws ends up with a push for the organizations and companies to have better data strategies. So the data strategies should be covering all data aspects about that companies, but also should be aligned with the broader corporate strategy. It is a must. And I mean, especially in the second half of last decade, we can say it became a real business priority for all the companies. And I think it will continue to be a priority that we need to address with several actions, such as very detailed data compliance programs. And of course, company culture will be a very key part of these data compliance programs. But all these comprehensive legislations push all the legal people, along with all technical and corporate people, I would say, defining their data strategies. If there is no data compliance programs in place, pushing to define and set the compliance programs and execute it in a regular manner.
So you mentioned the GDPR. For most of the people sitting here, do the companies that they work for in this region have to also comply with GDPR?
Yeah, that is true. By the way, when we talk about GDPR and other local regulations, still there are a lot of countries which do not have local regulations. But especially starting from global companies, even if they are not pushed to be obliged with regulations, the trend is being proactive here and starting to prepare yourself to the upcoming legislations. We see this very actively in Middle East region, of course. So regardless of the size of the companies, it would be very wise to start themselves and increase the readiness to put in the compliance programs in place.
Manish, being a practicing lawyer in India,
Yeah.
how were the compliance issues there?
So as far as India is concerned, we do not have any specific data privacy law so far. There has been attempt to formulate laws, but somehow it has not been passed by the parliament. Now, the government has very recently tabled another draft of the data privacy law, which is, I would say, very comprehensive, and it is trying to balance out all the stakeholders, and hopefully that legislation should be passed in next a few months' time. But as far as GDPR regulations are concerned, this law is also inspired by GDPR regulations, because GDPR is setting the gold standard as far as data privacy is concerned. And that even if there is no law as such, but when the Indian companies are interacting or getting into contract with an European company, they are bound to comply with GDPR regulations because that's one of the requirements. So I would say that the Indian corporates are anyway aware about the GDPR regulations. It is just that we do not have any specific legislation. And that legislation, as I said, that it should come soon. Some of the important factor about the legislation is that it is not trying to get into too many details about the PIIs, critical data, sensitive data. They are trying to keep it simple and leaving many things to be decided by the regulator who is going to be appointed under the Act. So it's not that they're trying to define everything upfront. Many things are left to the executive body whenever they are appointed post enactment of law. And that's a wise step to do, because in the previous draft bill, the government was trying to put too many information into it. And somehow they got so many suggestions that they had to withdraw the bill and said that let's formulate a new one. And that's the reason it has come up like that.
Thank you. Okay, so Nahla, how can we prepare our clients and internal stakeholders for their journey towards compliance?
Thank you, Noor. I think this is the or the most important question that we ask about data privacy. How to prepare our internal stakeholders or clients in their journey towards compliance. So when it comes with any new law, the question is always, how would this affect our business? How would this affect our activities? How would this affect our operations? One of the most very important exercises that we like to start with is privacy impact assessment, which is basically what we do to identify what are the activities that we engage in as a company or for our clients, identify what are the risk areas, and how can we mitigate that risk. I don't believe there is any company in 2023 that will not be affected by data privacy. Even when it comes to HR information or gathering data from employees. So it's gonna affect everyone. But with business operations, it becomes a little bit more critical, because I believe data privacy is the new consumer protection law. And to a certain extent, it will affect a lot of our data-driven marketing activities. And we can see from the headlines that data privacy is already making a buzz. Everyone is speaking about the major litigations when it comes to data privacy, companies which were fined billions of dollars because of lack of compliance. And it becomes not a luxury anymore. Everyone is starting to be aware and acknowledge the importance of compliance, and they are willing to invest in compliance with regards to data privacy, not only because of fear of non-compliance and fines and its implication on the reputation, but also because it reflects the business ethics and integrity of the companies that engage in data privacy, and it will definitely have a return on investment with regards to their image, reputation, and the trust with their consumers.
So you mentioned the data ethics and business integrity. Can you just elaborate on that, on how compliance will be affected?
So my favorite thing that I use when I speak to my team members about data privacy is data ethics, because I believe this is the subtle and the non-legal terminology when we talk to data. So if you want to simplify the concept to a non-legal speaker, we just use data ethics because it's more anchored into our moral compass, and it's very basic. What we believe as a company, as a team, as people: transparent, fair, expected. So if you as a person do not expect your data to be used in that way, or you have an expectancy for the company that has your data or the party that has your data to inform you in certain cases when they want to change the use or expand it, or to give you some kind of a freedom to withdraw your consent at any certain point of time, then you as a company should also give the same kind of ethical treatment to your consumers, to your employees, and to your data subjects.
Thank you. So Nick, you're not an in-house, but you're from a position where you have to actively advise other businesses. So what would you tell an organization about pragmatically complying with their data?
No, thank you. Good question. Well, first and foremost, given that I'm not a lawyer, I think one of the really important aspects is to translate the law that's in scope for your particular business. So once you translate the law into actual requirements, then you can start to understand, okay, what parts of the business, what parts of my organization is going to be affected. Now, once you understand that, then I think one of the most important things is stakeholder alignment, particularly if you have an organization that's spanning multiple jurisdictions, multiple competencies. Maybe the data you hold is not only just customer data, but also employee data, supplier data, which is all in the purview of these privacy regulations. So stakeholder engagement, understanding who could be current or future privacy champions. And then once you have that stakeholder alignment, going forwards in your compliance journey, it will be a lot smoother. Now, coming from a data background, I think data discovery is really important to understand the gaps in your organization in order to comply with these privacy regulations. So typically these privacy regulations are saying, look, you need to understand what you are doing with your personal or sensitive personal data. So any data that can identify a living individual. So yeah, how do you go about doing that? Well, there's a top-down or bottom-up approach. Typically, it would be great to do both. And what I mean by that is, from a top level, going out to the business, going out to the different stakeholders, and asking a series of questions with respect to how personal and sensitive personal data is governed. So this could be in the form of a questionnaire, or you can go a little bit further and use technology to unearth where this personal data is. And this personal data could be sat in electronic format, it could be sat in physical format, it could be cross-jurisdictional. But off the back of this data discovery exercise, once you've catalogued what you have in-house, you can start to answer some of the fundamental questions that these privacy laws ask, which is, what type of data do I have? Is it customer, supplier, employee data? Who uses that data? Who accesses that data? How is that data protected? Going back to how that data is used, so where's that data being transferred to? Is it sat in one system? Does it move to multiple systems? Does it go to third parties? And from a legal perspective, do we have relationships with those third parties? And if there are there the appropriate clauses within the contracts to facilitate that movement in a manner that's compliant? So data discovery unearths all of these different topics, different ideas, and the answers to those questions can then later lead you down the path to, okay, how do I prioritize my compliance implementation program? What parts of the business do I need to focus on? And depending on the types of risks that are coming out in your organization, what should I prioritize first? So using data analytics, for example, you can take that inventory, or what we call is a record of processing activity, and then start to filter, manipulate, and just really understand, okay, where should my focus efforts lie? And that's when you can start to align your policies and procedures off the back of that inventory exercise. So when I'm creating, or when the lawyers are creating policies around policy notices, privacy notices, one of the aspects of those policies is to be transparent. And what I mean by that is sharing with your customers, suppliers, employees, what type of personal data are you capturing, what are you processing, how are you using that data. So all of those answers can be retrieved from that data discovery exercise. And I talk about procedures as well. So some of you may know that one of the requirements for organizations, or should I say one of the individual components of being a consumer is that you can ask organizations who's processing your data to give you a copy of that data. You can ask, what are you processing on my behalf? How are you using that data, et cetera, and that's called a data subject access request. Now, to facilitate that process, particularly in a large organization, can be super tricky, because you need to understand, okay, where does that data sit? Again, going back to the data discovery exercise, and then you need to understand, okay, off the back of this request, is it legitimate? And if it is legitimate, okay, how do we package that data up and in a timely fashion then provide that to the individual who's asked of it? Now, looking at GDPR as an example, I believe, correct me if I'm wrong, it's 4 weeks to turn that particular request around, which can be very tricky if you've got multiple requests coming in at the same time and you haven't got a team to facilitate that. And then one of the other aspects is all around data minimization. So data minimization is a concept off the back of these regulations whereby you should only keep the data that you need. And that can be very tricky because, as we all know, data volumes are just going through the roof. You need to really kind of get to grips with, okay, what data am I collecting, and do I really need to collect that data? And then, once you've done that, you need to really understand, okay, if I don't need that particular piece of data anymore, then how do I pragmatically go ahead and delete that data without compromising day-to-day business activities and in a manner that's safe? So yeah, probably quite a few points there for you to digest, but I think in a nutshell, first and foremost, for those who haven't done a privacy exercise before, it's mainly to translate the regulatory requirements and do that data discovery exercise, and off the back of that can lead you into the questions that need to be answered off the back of these regulations.
Thanks, Nick. So following your review of the answers you get from a data mapping questionnaire, what would you identify as a company with that is a high risk? So is there a criteria for the volume of data collected or the type of information that's collected? How would you categorize a company that is a high risk, in your opinion?
Yeah, no, absolutely. There's many different ways we can do this. I think the way I would do it is, first and foremost, probably focus on customer data. I'm not saying that employee supplier data is less important, but particularly customer data being leaked out into the wider world, you might have a bit more of a spotlight on you. So first and foremost, I would personally focus on customer data and then segregate the personal data in between highly sensitive personal data and personal data. So what I mean by highly sensitive personal data is data related to, for example, children, religious beliefs, et cetera, et cetera. So I'd focus on that highly sensitive personal data and data that's potentially going to third parties. So, of course, many organizations are using, for example, cloud services or other third parties to do services on behalf of them. So I would certainly look at that, and again, going back to my point earlier, making sure that there's the appropriate clauses in place with those providers to ensure that that data is being kept secure. Also, yeah, as the point you highlighted is probably the volume of data as well. So in a nutshell, I'd say data volume, highly sensitive personal data. I'd certainly look at customer data. Any data going to a third party. And lastly, data traveling cross-border. Because again, you need to have agreements in place, whether it's internally or externally, and you need to ensure that there's appropriate safeguards in place before you move that data outside of the organization.
Okay, thank you. So next question to either of you, probably Nick is probably going to be the one to answer this one. Right now we have the Saudi Arabia and the UAE data protection laws, which technically still not yet in effect. Should companies still comply or not?
Yeah, maybe I'll take the first stab. So absolutely. I think data privacy goes hand in hand with data governance. And once you start to get to grips with data governance or data privacy, you can use the same output for many different use cases. So not necessarily just responding or complying to the regulator, but also keeping your house in order. We all know that storing data can be costly. So the exercise itself can be used as a way of saving money. So yes, absolutely. I would say that even before a regulation comes out, it's prudent to just understand what's inside your four walls, so that in the event that something does happen, maybe it's a data breach, that you're well equipped to be able to respond. Maybe I'll hand over to somebody else.
I think that yes, the laws are not yet enforced. We don't have executive regulations per se. We don't have a governmental entity that's monitoring compliance. But as everyone was saying, we have GDPR, which has been there for so long, setting the path, setting the standard. We're all very familiar with the concept of data privacy and what we need to do to comply. What I believe is the right thing to do now is to prepare for compliance, which is having all the steps that we were talking about, having impact assessment, identifying the activities, identifying the areas where we need to work on, creating action plans, calculating the cost of compliance and the cost of non-compliance, and prepare our teams and our clients to start complying, because even if it's not there yet, but at least we know it's coming. We know for sure it's coming. And delaying our readiness is only going to cost us more, as far as I believe.
I can answer in the context of India. So though, as I mentioned, the law is not implemented, but as far as data privacy is concerned, it has a behavioral aspect also. It is not only a law, because you can't just enforce the law. It needs some behavioral change. So I typically advise my client that it is this act will be enacted. It's not 1 year, 6 months, or whenever, and thereafter the government can give you 6 months to 9 months to get ready and be ready for that. But at the same time, you're contracting with many countries or many companies which are based in different jurisdiction wherein GDPR regulations are there. So it is good that we start implementing it now. And as I said, that it is gonna be a part of behavioral change. So first, two things are important. One is the employee, or the person who is going to do compliance, they should be made sensitive about it. That's one. The second aspect is the data principle. The data principle means the person whose data is. That person should also be made aware about the importance of their data. Because ultimately we are taking their consent to use their data in various ways. So it is important that they should know how their data can be used, misused, how that can be monetized by others. Unless we do that exercise, this legislation may not be implemented fully. So while companies are, we are advising client to undertake the compliance checklist, doing all these things, it is equally important that the society should really be, made more sensitive about the importance of their data and what are the data that is important for them, what are the data that they're going to feed in the on the e-commerce website, their mobile. Ultimately, these are the source of data. And what you are just saying, yes, I agree, without realizing it. So somebody has to make them realize also. So that aspect should also be covered as we go on.
Thank you. As for Middle East, and also not only for Middle East, for any other country which doesn't have the data protection law in force yet, I mean, I completely agree with panelists that they should start preparing and they should at least start making a plan. Because, I mean, when we look at the data compliancy programs, we can elaborate it a little bit later on maybe, but it is not a very easy task and it is not a very quick task to set a data compliance program in place. It will require a good amount of time to, as Nahla was saying, it requires a detailed assessment. First to see the as-is. And after seeing the as-is, only then the to-be can be planned about which would be the better data compliance program for that company or organization. That's why, I mean, to sum up, I completely agree that the countries, the companies should be preparing themselves.
Okay, so this next question for the audience. By show of hands, in your organizations, is there an appointed data privacy officer? If there is, raise your hands. What do you mean serious? So from what we understand, you don't actually have to have someone appointed as a data privacy officer if you are not processing a significant amount of data. Is that correct, Nick?
Well, yes and no, I think. I think it's prudent for any organization, regardless of the volume of data that you're processing, to have somebody who is responsible for privacy and protection, particularly going forwards with the comments that have just been shared. I think it's not just about compliance anymore, but it's more of an incentive for organizations to demonstrate that they are protecting personal, sensitive personal data, customer data, because I think going forwards, people start to choose brands and organizations who are being sensible and ethical about the data that's being processed by them. So I think, from a legal perspective, yes, of course it could be argued, but from a non-legal perspective, from a compliance, from a commercial, from a ethical standpoint, absolutely, data protection officer should be in all organizations.
I believe, Noor, it's a very interesting question. Are we appointing a data privacy officer just to comply with the law, or because we're really concerned about our governance model and how our data is being protected? So there's a lot of discussions and separations between data privacy, data governance, and data security. And I believe the role of the data privacy officer is not just to check a list that we are compliant or whether it's needed from a compliance standpoint or not, but it's more on the actual work on the ground and how serious organizations are taking data privacy and their governance model and ensuring that they have the right governance in place.
So I think as a part of corporate governance process, data privacy has to be a necessary aspect of it. Because so far it is coming as a different topic. It should not be a different topic. It is a part of the corporate governance that how a company is actually, who are dealing with customer data, are sensitive to it. So when we look at the compliance for tax laws or respective companies act or contractual arrangements, this should be one of the metrics within the corporate governance as to how that company is managing data. And it is not far off, like in next couple of years, most of the countries will have to face this, in terms of data privacy, because we are moving towards it. It's not far off. So better the companies get into that mode of corporate governance, which has data privacy, data protection a necessary aspect, so that the early we reach there, better it is for everyone.
Noor, about your question, I mean, I want to go just one step back about DPO. For instance, data privacy officer is the main data privacy role in GDPR, and in GDPR it is regulated as a mandatory role. So it is given for a lot of countries. And it is given for the countries which adopt GDPR for their local laws. But there are also several countries whose local laws do not require a mandatory DPO. And I mean, when we think about how a DPO can be positioned in a company, I strongly believe that even though if the law does not require a DPO, having a DPO would make perfect sense. Because I mean, if we look from business perspective, I think it makes perfect sense to assign a role to manage all the data protection risk of the company, so that the leadership can have better visibility, and this can also be adapted in the business operating model. And I also believe this gives, I mean, having a DPO gives a competitive advantage to the companies, because I mean, if a company, even though if they are not obliged, taking data protection this seriously, I think this is also giving to their clients and stakeholders an impression like, their data is protected and their operations will be completely smooth and nearly risk-free.
So those who didn't raise their hands, speak to your HR, have a position open. Okay, we'll go into one more final discussion before we open up to questions. Do we have to locally store data in order to be compliant? So data localization is becoming an issue now, even though it's not technically stated in the law. It is becoming an issue for a lot of companies here.
So in terms of the new law that has been proposed in India, there is no such mandatory requirement. What it says that the central government will notify the countries where data can be stored. So what is not saying that data has to be locally stored. It is keeping that room open. So data can be stored in the country or in the country which is later notified by the central government. Whereas in the earlier provision by the RBI, which is a federal bank, they put in the restriction on all the fintech companies to store data within the country. So that was a big compliance issue for them. Thereafter, with the new legislation, the idea is that data should be stored in the country, or it can be stored in a country which the central government will notify, and that's how the current frame of work is.
Yes, I think when the country started to do legislation, data privacy is a very fresh subject for a lot of people. And it comes naturally that when it's something is new, we try to go for a restriction. Later on, when they had the discussion with the private sector and when it came to application, they realized that this was not practical. And it was it made more sense to put in the proper governance in place when it comes to where we store data than just to restrict it to a localization requirement. Because if every country required that their data would be stored locally, it's as if you are, from a logistics and supply chain standpoint, restricting the moving of goods and warehousing to a certain country, which doesn't make sense in terms of operations, in terms of the new ways of doing business, the business models in which the private sector operates in 2023. So I think it was the right thing that we focus more on governance, because it doesn't matter which country you're storing the data so long as it's stored according to certain specifications, to certain requirements, and we can trace how it's being stored, where it's being stored. We have governance and data retention policies to guide us through the process. So I think localization is not a per se requirement, so long as we have the proper governance model around it.
Well, yeah, I mean, absolutely, totally agree with you. Let's hypothetically say we have to go down the route of localizing data. How could you do that? So I guess, again, going back to the data discovery example, identifying what data you have where that personal data is, and how you can potentially deconstruct that and keep that data locally. Now, there's different ways you can do this, and look at access management as an example. Look at ways in having, as you said, secured methods of looking at that data in such a way that doesn't mean it needs to move out of country, but people can still look at that data from other jurisdictions. So absolutely, I believe it's going to be a headache for organizations to grapple with. I completely agree that with technology advances nowadays, you shouldn't have to localize data, but I can certainly see that there are going to be some use cases, particularly in countries that are quite sensitive about their data, particularly KSA as an example. I've come across one of my clients carrying out a case study around, okay, what if we have to keep our data in KSA? How do we go about doing that?
And if I may add another aspect on this data storing matter, not only about storing, but also in general, when we talk about data processing, data controlling, I think the definitions also matter, and the definitions differences in between countries also matter. Because, I mean, in current business models, it is not only one country. So, and when we have more than one country and both countries have their local data privacy laws, I think everyone should avoid assuming the processing means the same thing in both laws, or storing means the same thing. So in line with what Nahla was saying, when this is managed in governance, I think there is a good portion of good interpretation and knowledge of the local laws, and then translating it into the governance.
Okay, so we've got just over 3 minutes left already.
if I may start, I mean, as for your first question, I don't have a background about Kuwait, but I can speak about UAE. And as UAE data privacy law drafts, I mean, it is mostly in line with GDPR. At least, I mean, I can say it is very well inspired by GDPR. So there are still slight deviations, but I think for UAE it will be more straightforward since there is a good GDPR example, and in the region there are lots of global companies which are already considering this. And as for your second question, for GCC region, I mean, of course, a unified legislation could make things better and very easier for business processing, because I mean, today if we look at to Saudi, I mean, when there is a data matter related to Saudi, I mean, we all know that storing data is an issue, so you know the business model changes in line with that. So if we have a unified, of course it will be more easier, but I mean, to my personal view, I don't see it very likely to have a unified legislation for GCC or even, I mean, except for EU, other regions, I would say.
I think it's not about having unified law, but a unified common understanding of, like Emel was saying, for example, who is the controller, what is processing activity. So I think even if we don't have a unified code per se, so long as we're all aligned on and we have meeting of the minds on what exactly is the activity that we're talking about, the limits and the scope of liability and responsibility of each party involved in the data flow transaction, I think implementation would be much more efficient, and it would be much better for the data subjects and their rights. So the end purpose of the law, which is the protection of the rights, this would be the ultimate goal. I believe because it's a very fresh concept, we didn't reach that point yet. Hopefully, soon enough, we will all reach that meeting of the minds, especially when the law comes to application, and we see how the authorities, how the courts are interpreting these terms, and then we can have a better understanding of where are the areas of differences or discrepancies between the different laws, and then we can start working or advocating on how we can make it more of a unified concept. I hope we answered your question. I highly doubt that not from a data privacy perspective, but from a jurisdictional perspective, any country would attempt even to do that. However, notifications for breach, we are still, because we don't have the entities where you are supposed to notify. So if you're working on a governance model for notification, you can put into place certain notifications for other jurisdictions, even if they are not there by law, because from an ethical standpoint, if the breach is related to data that was collected or processed or controlled in that country, even if breach happened in another place, it makes sense that we have that in our governance model. I don't believe it's a matter of enforcement per se, because from a jurisdictional perspective, I don't see it happening, but I believe this can definitely be reflected in our internal governance models.
Are we allowed to answer? Yeah, go on.
I think so, because as you rightly mentioned, the data protection, we have the investment protection treaty among many countries, wherein we treat as if the investment is made by some resident, and they have all the protections. So that is the way forward for data as well, as we evolve, because these data protection treaty, the investment protection treaties are there since couple of years. But data, as we discussed, it is evolving subject matter, and that could be the way forward, I guess.
Any more questions? Because we are way out of time. That's it. Thank you, everyone, for listening to us. Hope that was informative for you.